Greetings and salutations from Sunshine State, Florida. Benny's back, ladies and gentlemen. We got the property tax going all over the Sunshine State, and Benny is leading the charge. So he's got some new information about all the things he's been filing and what the judges said, and he's going to get into it. Welcome, Benny.
Well, it's good to be back. Thank you very much, Gary. I'm going to start off by catching everybody up what's been going on with the property tax case a little bit. For those of you who are seeing this for the first time, I filed for my property tax lawsuit back in February of 2024 this year. And a month into it, the judge dismissed the case, complaining that the gravamen of the complaint was that property tax was unconstitutional. That pleading was 90 pages, and I got 14 days to amend it. But he labeled the first pleading frivolous and without legal merit, which put me under an onus. And so I decided to file my amended complaint anyways, and that was done within 10 days. And ironically, the judge had ordered the case closed. So they reopened the case and asked me to include a memorandum of why I was not barred by the Tax Injunction Act. And being a pro se, I did the best I could at the time. The case went through the flurry of the motions to dismiss, and there was a motion to stay discovery, which the judge granted within 2 hours. But then finally, a couple of months later, after June, I filed a motion for jurisdictional discovery. The purpose of jurisdictional discovery is to ensure that you're in the correct court for the right jurisdictional reasons. Now, you could plead correctly, but be like, nope, this should be in the state court, not the federal. Taxation should be at the state court level, however, because taxing property directly is a violation of a constitutional right, this is where the argument has become lost. So, am I barred by the Tax Injunction Act per 28 U.S.C. 1341, or does 42 U.S.C. 1983, which enforces my rights on the state's precedents? That is the basis for this entire lawsuit at the appellate level now. So once the motion to dismiss were granted in August, I appealed in a timely fashion, but at the same time, while that was going on, I filed a petition for rulemaking into the Department of Revenue, seeking to clarify how to request the burden of proof when I was in an appraisal situation before the Value Adjustment Board, or to change the verbiage to take the tax off the rolls. Those were both denied. But now I had some constructive evidence that I couldn't do what I was looking to do. I also filed a petition for a writ of mandamus at the state level. A petition for a mandamus is to compel an officer or state official or a judge or an agency to do their duty and produce public records that show they've completed these duties. In Florida, that's Florida Statute 119 and I believe Article 121 of our Florida Constitution, saying that these public records are to be required. We'll get back to the Constitution part of it. I filed all of that while I was working on my appeal brief. That was filed right before Hurricane Milton, which had lots of damage down here. Flooding, trees down, it's barely cleaned up still. And then, right before Thanksgiving, I filed my reply brief. And again, the crux of our argument is, are we taxpayers or non-taxpayers before you apply the Tax Injunction Act? Because either rights are inalienable or they're prescribed. And that would be against the grain of the Constitution. So where I stand right now is the petition for the writ of mandamus the motion to dismiss was granted, but the judge allowed me to amend into a complaint under Florida Statute 194. So I did that in about 10 days. And I think this is the best pleading I've done yet. It's only 16 paragraphs, which is, to be dismissed have to be construed as true. So And we'll come back to that later on in the conference here. But right now, the goal of what we're doing here today is to try to reorient everybody what you're looking for in your state, what you're going to do as you go along the property tax process, because I've done it backwards. Well, I could have done it this way. So let me save you guys the grief with a little bit of education and whatnot.
So just so everybody knows, this was Benny and I's third take. We've had some technical difficulties out here in person, so he was he was able just to answer all my questions that I asked in the first two takes right there. So in one big swoop. But so you served the new lawsuit. Just
Okay, and back
where
to
were we?
ourselves after our technical difficulties. So what we were talking about here is, this is my case that I refiled as the amended complaint. In Florida, Article 1, Section 2 discusses specifically natural persons. This is very, very important for us. So what we have here with this amended complaint, we sued, this is an action to contest ad valorem tax assessments. Court has jurisdiction pursuant to 194 Florida statutes and Article 5, Section 5 and 20 of the Florida Constitution. I wish I had added Section 21 because that requires the judge to construe everything de novo, but if you can sneak it in during a hearing, you should be okay. Again, construing this pleading is to be true before allowing to be dismissed under a motion to dismiss. It's true there were Article 1, Section 2 natural persons. It's true the appraiser is a necessary party. It's true the collector is a necessary party. I didn't find the statutes for this in time, but it's true that the political division receives ad valorem taxes on the subject property. Defendant Zingle is sued as the executive director of the Florida Department of Revenue. Here's the reason why the executive director is an important part. He is the one who promulgates everything for the clerks, the tax collector, the assessor. All of them have these rules that they're required to follow that are being ignored because each one has its own administrative duty. That's the responsibility of this guy. No, go see this guy. And after a while, when none of us get the answers we have, it's true that this is where the private owners of private property here are named after is the subject property. Now, we specifically said private property and not real estate. If they try to come back and say that's real estate, they have to prove that it's real estate. It's true the assessor just assessed it as just value, and this is the assessed value. Hereinafter is the assessment. It's true we paid all the taxes. It's true we've performed all actions which is the required to perform for establishing this action. In Florida, 194 does not require us to go before the Value Adjustment Board to seek judicial remedy. We can go straight there. It's true the appraiser failed to comply with Section 193 of the Florida statutes and professionally accepted appraisal practices in assessing the property. This also could have been 194.301, Section 1, but the intent is he has to meet all 8 just values.
So it's your contention that the sheriff and the tax collector are all just following the rules of the DOR, right? And so,
not the sheriff necessarily. The sheriff has to follow the promulgations of the Department of Law Enforcement. The Department of Revenue has to deal with taxation, what things touch on those aspects. That would be occupational licenses. They collect the revenue for that, or they redirect it. Again, there's different layers and whatnot. You would have the Department of Health. They're the ones who are responsible for all the licensing with the health from there, but the collector collects the taxes. For the county level, they have nothing to do with the administrative level, which is where the confusion is coming into play. For example, off of what you're talking about, in order for this property to be classified as agricultural, a return has to be I have to get a license from the Department of Agriculture first. Then a return is submitted to the appraiser. Then a return is submitted to the Department of Revenue if you're a business or other legal entity that is producing income in the state that is taxable as income produced from the property. We have the right to be rewarded for industry, so they can't just necessarily come in and tax that. That's a direct tax.
But your reason for bringing the Department of Revenue in is to corner them.
No, they promulgate the forms that
Right.
the department, each agency is following. So there's supposed to be something created for the assessor to use to assess the property to meet all HS values. The form used to announce that the tax roll certificate is completed. That's Form DR 403. That was produced by the Department of Revenue and it's used for them. So all those forms that they're using are the ones that have to be promulgated by somebody as a record of something said or done. So that's why you need to bring the department in. Administration has been decentralized, so somebody representing this part of the state can tell the municipal corporations or the political subdivisions of the state how to perform their duties. Does that answer the question?
Yeah. Just to clarify a little bit. So, but you were saying that they stopped the they stopped the way that you could get people taken off the tax rolls back in '86. Is that what you said?
So let's look at this. Let's put this question aside. We're going to cover that in the other material.
Okay.
Coming back to the complaint, we leapfrogged using a petition for a writ of mandamus and saying in the granted motion to dismiss, the only document that the property appraiser is required to produce and provide to taxpayers is the trim notice, which is not a possibility of law because the trim notice is the levy. Where's the assessment? You can't create one before doing the other. Then the final thing is it's true that the appraiser has levied the plaintiffs without first determining whether they are taxpayers subject to an ad valorem or property tax. See section, and this describes what a taxpayer is, which is a corporation or other legal entity that files a consolidated return. And then my wherefore clause has the relief I'm seeking, which includes removing subject property from the tax assessment roll. So those are all the parties that make it successful. And that's the reason why we sued everybody. If I had included the value adjustment board, then I would have to sue the clerk of the court. So by not doing this, I have one less party to answer to. And as any pro se knows, you're not dealing with just one lawyer, you're dealing with 3, 4, 9, 16, and they like to juggle the games and change the lawyers. So what can we do at this point?
Yeah, when you start getting 5, 6, 7 attorneys in a case, then they all have different questions, and it really does make it a lot more taxing to do this, especially without help.
Well, that is one of the reasons I really advocate for our groups, because we are our own assistants of counsel. We're the ones who handle cases. Like, if I want to reference someone who's an expert in res judica, I'm going to go talk to Tate. You're going to go seek the person who's the specialty. Jill is the expert in this whole discrimination. By this case with the Stratz, Kurt is obviously the expert in family law, and incarceration under the Sixth Amendment is a cruel and unusual punishment. We all get our own specialties, and
Sure.
that's like where the Google you go ask, if you will.
Right.
So that's why you kind of, as I get into it, why you have to develop your peer groups.
That's right. That's the beauty of being in the Telegram group, folks. The Telegram groups are not built for you to come in and ask, how do you do something from scratch? What they're built to do is, after you've read the constitutional law section of AMJUR, after you've read your own constitution, after you have read a bunch of stuff and case law and know what you're talking about, then you can come in and ask people, hey, a more sophisticated question. But it requires you to obtain knowledge. This is not a template that you can You can just plug and play. This is not how this works, because eventually you're going to have to stand before that judge and explain to them what you wrote. And so if you don't understand it and you're just following a template, you will fail and fall on your face for sure.
And it will come back to bite you in the butt for sure.
Right. So please do the initial reading that we've outlined, and maybe I'll do another episode with exactly what we need to minimum basis for you to read before you start doing anything in these. But sorry, Benny, continue. I felt like that needed to be said.
That's okay. I mean, it's important to emphasize these things and realize how big and complex this is. So, this is Property Taxes Are Indirect, Guide for the Pro Se. Goals of our session. Per se, who are we construed liberally? And they do mean that in the courts, but we can plead much better arguments so that we don't have to be. I want to dispel a bunch of patriot mythology, and we touched bases on this in a couple of the other sessions and other Legal Beagle podcasts, but for property tax purposes and stuff, let's clarify some stuff. What are the territories? Why did we have the settling via homesteading and land patents to create states? Review the Constitution's construal implications and tax rules from the Founding Fathers' standpoints and breaking down the statutes and codes. About the idiot presenting. So, I got involved in politics and law in 2018 when the hemp bill first came out, and that was a big hub because for the first time, America sort of openly acknowledged, hey, we can do something with this plant. And for me, I had an interest from the real estate perspective, so I saw an opportunity to go with a group called Florida Cannabis Activist Network and jump in and start, just go, just learn, just you don't even have to do anything. They want you to get your feet wet. So if you find groups like that, or maybe you've done something with your school, or you've done lobbying for an occupation or a trade, those are all things that you can do where you can begin learning about your legislative process. And everybody needs to go and do this. During COVID, I studied the basics of law because code enforcement wanted to come by and tell me to mow my lawn. And no, I'm on farmland. Why am I mowing my lawn in the first place? This is not supposed to happen. And thankfully, we defeated code after diving into it and finding all of the loopholes that said, I can do everything I'm saying I want to do, and you can't restrict me on this. There is a huge difference between a noxious weed and a native plant. So, and Gary's got some video on that. I'm sure he'll snip into later on in this video.
And just so everybody knows, hemp was originally a very prominent plant here in America, and they used it for clothing and the timber industry and all kinds of different things. But William Randolph Hearst and Mr. Rockefeller got together. William Randolph Hearst owned about 80 newspapers across the country, and they did a yellow journalism campaign, which is, false equivalencies to make everyone think that it was a bad thing because Rockefeller was eating into Rockefeller's profits. So William Randolph Hearst and Rockefeller got together and got it banned.
And that was the beginning of the robber barons.
Right, the robber barons.
So I also did a detailed study into income tax in the Public Salary Act of 1939, and as a result, I'm no longer required to file income returns yearly with confirming paperwork from the IRS. No, don't ask me. Go study. I'm not helping you. You've got to do this on your own because you have to defend yourself in front of the court if there's ever a problem. And then after that, I began the property tax study in February 2023 through Alphonse's group and TikTok. Then I filed it in 2024. But as I explained everything earlier, I've amended the pleading, I'm in the federal courts, I'm in the state courts, I'm all over the place. That's what happens when you do this stuff. Keys to studying pro se. Find peers like we just talked about. You're going to vet every single resource you have, because I guarantee you somebody has shifted the words around, and if you don't get the actual case law before quoting it, they have computers in the judicial circuits that are going to eat those quotes alive. And you're going to, like I said, you're going to get an overload of information. And we'll have to figure out where and what and why it connects, which is what I'm going to show you in this course. Make it easier for you.
Yeah, and
Now, lastly, take jurisdictionary.
Okay.
That's the most important thing for at least learning how to write a pleading or understanding what is going on in court. Maybe you don't understand it, but it's your textbook. It's the textbook for the pro se litigant in digital form. So go get yourself a subscription for a year or two until you understand how to do it. Lastly, avoid political mythology, sovereign city, and verbiage that triggers the courts. And you see a lot of this stuff on TikTok, and bad idea. Tips for the pro se game. Create your profiles, create your stockpile, Telegram, your law property tax group. I have 2 or 3 of them. I can go back to them and refer this information anytime without losing this anywhere. That's the benefit of it. Plus, you have access to your peer groups. I prefer to use for my legal library case tax. It's free. You can get around the paywall if you know how to use the right questions in the search bar. In your groups, or recruit in your groups for your specialty or for enthusiasm, or go join somebody else's until you can start your own.
Or
avoid commerce.
Law libraries are all over the place. They have free Westlaw at most of these law libraries. So any university or huge public library, you can be able to go look at Westlaw if you like there.
Absolutely, absolutely. They're there. If you avoid, you don't want to say I'm not in commerce. You are not engaged in the privilege of use. Because use is a very specific legal word that is an argot word, as opposed to what we've turned it into the slang for today. Always remember to apply the 9th and the 14th Amendments, because prescribed rights are being used to impair and deny your inalienable ones, which are protected under the 14th Amendment. Pick your specialty, the problem that got you here in the first place. And everybody's going to have one. Gary's got his own story of what, a fishing trip?
Well, that's really more Brandon's thing, but the not being able to get in the courts or casino hotels and whatnot with masks and vaccines. So we're more on the COVID front.
So you can do things like CPL, so declare law, survivorship, Justin Carlson. Those are people who are struggling with CPS situations like that. Traffic tickets, ordinance violations, code enforcement, everybody's running into that. Traffic means you are engaged in the use of your car to transport persons or property on the highway. No, you're not doing that, so you don't fall under the jurisdiction of the local or the state. Property tax, income tax, they're both the same thing, but from a different perspective. You have First Amendment audits, Second Amendment challenges, Fourth Amendment, Fifth Amendment. We can go on through the list. I studied conveyances of land because I'm a real estate agent. Government certificates, warranty deeds, land patents, Murphy deeds, ladybird deeds. There's an endless list of them, and they all relate to things regarding freehold. And then we could get into a discussion regarding allodial title. You have habeas corpus, incarcerated, favorite drug habit, legal issues. Declaratory statements, requests for rulemaking, legislative sessions, pro se lobbying. You learn how to write your own bills and submit them to senators. There's lots of ways to become involved and have a specialty. So the first time you're in court, you're going to put your hours or months or years of work into writing and research. You'll draft your pleadings, respond to summons with affirmative defenses. You'll talk with your peers. You're going to look for mistakes. You're going to try to find a way to condense something down into size. You fill pages with inspired prose, case law, overarching legal theories. Submit everything to the court docket, and I'm sure everybody recognizes this famous Major League Baseball scene.
Game time.
I'm just going to look at what you're saying, throw it on the ground, and pee all over it. I guarantee you, just the first time you've done something, it will happen. You've got to ride the bicycle in the training wheels first. So welcome to the 1% willing to go pro se and the 100% who will have to amend.
That's fact.
All of these things in here, they're just important. The case will be dismissed for the stupidest reasons. Take a day off. Research why it was dismissed. Change your pleading style. Maybe you're putting too much information in there. The cleaner it is, like I showed you in my earlier pleading, the harder it is to dismiss. Novice pro ses vomit everything. We put everything into a pleading that should be left for discovery. So just remember that. Take the stuff you want to show them and save it for discovery. Cut that fat. Like I said, I went from 90 pages down to 40. That helped, but now I can get it down to 20. Lastly, get sleep, rest, spend time with your family. This hamster wheel will never stop for you.
It's
And this
definitely
was the quote I was looking for to put into my reply brief, but I got close enough. We are the Patrick Henrys and John Locke's of our time, and the battleground is not a bloody field with cannons firing, but courtrooms with canonical riposts. And this is from our good friend Kurt Benshoff, and it's so true. This is what we are doing now, because we can't go and take a gun and go shoot the tax collector anymore.
no, don't do that.
I just want them to do their duty right. You know, you're a constitutional officer. You should understand rights are first before you apply a tax onto a natural right. So let's dispel some patriot mythologies here. These are the important ones. My original line of studying was land patents. And a land patent was a deed that generally had the use as the highest level of title, state and U.S., until thus there was seizure and judgment. It doesn't convey any special privileges like they want to say in some of these allodial title manuscripts. It doesn't protect you from taxation by its status, none of that. You're still taxed by use. This Supreme Court case was dismissed, and somebody did everything that they tried to claim it will prevent a foreclosure. Go look it up. Not going to happen. Holding land is inalienable. So you have the right to possess property, people. It's in your constitutions and the federal constitutions. Work from that reference. It's referenced to as a allodial title. It is a valid and state constitutional right in Minnesota, Arkansas, and Wisconsin, I believe. There might be one or two others seen or referenced to in your courts. I believe Pennsylvania has reference to it in a case and whatnot. The recording divide of responsibilities occurred in 1908 with the disabling of the duties of the Bureau of Land Management and shifted it to the state's Bureau of Land Management. I believe it's become a forgotten duty with the enacting of the 1939 Marketable Title Act. This is theory for me right now. I can't prove it. In order to do that, I've got to go read about 12,000 to 15,000 pages of legislative acts. That's time consuming. I don't have time right now. If you want to understand what real estate is, read the Introduction to Law of Real Property by Moynihan. And it talks about what real estate is. It's a freehold because the state owns the property of the person or other legal entity that was incorporated into the state. That's what grants in rem jurisdiction, real estate. We've heard of the real of the Spanish coin. Well, that coin was the king's money and we were using it. So think of that term, real, how it was pronounced. This is real estate, but we call it real. These estates come with a bundle of rights that are fee simple. An allodial title is mentioned once and defines an alienable title in that law of Moynihan. Now, due to the crossover from de jure to de facto law in 1909, the 16th Amendment, the Great Depression, the Public Salary Tax Act of 1934-9, World War II, and the Chevron defense, the U.S. forgot we were protected from property taxation that was direct. So to keep it that simple, here's the shit that gets you into trouble. Pardon my French. You're going to access the C'est la Vie Trust. I know people going to jail for this right now. It's not. They've got years and years and years of recovery. The U.S., the state, the county is a corporation argument. Of course it is. It's a municipal corporation. It identifies a creature of the state engaged in government under the corporation rules. That's how it has to be done. The Marketable Title Act began the color of title question, begetting the land patent mythology. Go read into your Marketable Title Act. The UCC, property and trust baloney. Lots of trouble for you. It's appropriate for a true life estate reasons to be controlled by the UCC. The trust is the creature of the state and treated as such. So when you put it in there, you just told the state, here, I'm incompetent, take my property. State national is a political ideology that endorses dangerous ideas and verbiage that's defeated by the black letter of the law. Lastly, if you're going to play games with the judge about oaths inciting the living man theory, I'm going to come beat you because now I've got to defend against that stupidity in court. I don't always learn my lesson, but when you do, you bet it's the hard way.
Those are the best lessons learned, you know. Failure is the best teacher, honestly. I know that's no one wants to hear that, but without some failure, you don't learn anything. The soul learns through adversity.
You have to have your negative feedback.
Right.
So we're going to do territory, states, and their creatures. I wanted to take a minute to delineate these for a specific reason. To get into the argument about who controls who, there are two definitions. There are the territories of the United States, which includes the Organic Act of 1871 creating Washington, D.C. These are all the territories, Puerto Rico, Guam, all of that stuff. Things held by the Bureau of Land Management, still held under land patents. They're all territories of the United States. States are outside of that framework in a sense that they have their own constitutions defined by that framework. So we're going to put that aside for a minute. The IRS is based out of Puerto Rico. So its inherent jurisdiction is not the 50 United States, unless you are a creature of the state or someone subject to the Public Salary Tax Act of 1939. That's where an individual was broken off of a firm, and businesses in these territories use the NIC, whatever that number is. So we're getting stuff misapplied to us. Again, that's a whole other discussion. The 13 colonies didn't start with land patents. They started with land grants, and that's something else entirely. Now, if you go reading through the stuff I'm going to show you later, you'll see these grants being given to creatures of the state. So we just merely changed terms to reflect an administrative estate versus the judicial law of a state. Territories were homesteaded by land patent to bring them into the states by building up the citizen population willing to become inhabitants. You can't have a state without inhabitants to run the state. So the states create their own constitution, but they're limited by the supreme law of the land. And the whole point of it is to add more protections. I have protections as a citizen of the state of Florida that I don't have defined by the Constitution. State laws, statutes, codes, all of that. Those direct officials what to do. They define taxation, all of that interesting stuff. A tax or a traffic law for Nebraska may not make sense for Nebraska or Georgia, if all that makes sense. And finally, the inalienable rights of each state constitution is for the people, not the taxpayer with prescribed rights. And continuing on here, these are the things that most of you will find in your Division of Library and Services, if you will, which might be held by the Department of State. So you're going to go look for the territory and state acts of legislature that were the original future law. So in case I have here, acts of the Legislative Council of the Territory of Florida passed at their first session in 1822, together with the Treaty of Cession, the Act of Congress originating the territorial government, Constitution of the United States, Spanish regulations for the allotment of lands, Act. Then you come over and we have the acts and resolutions of the First General Assembly of the State of Florida, passed on its first session, together with the Constitution of the State of Florida and the Act of Congress admitting the state into the Confederacy and Union. Now, it took us 23 years to become a state, people. So this took time through the homesteading. And you could say every 7 years someone got their homestead, their land patent, and then they started becoming very active in the legislature. Now we have inhabitants. So our state becomes admitted to the Union. It's interesting to note that most states were approached in pairs back then in order to deal with the north-south disparity of no slaves and slaves. You have to have a state with no slaves admitted at the same time as a state with slaves. And I think our counterpart was Idaho.
It's a lot like the SEC. They got to add one from the east and one from the west.
Yeah. That's a good way of putting it. It was a football rivalry, except over the pigskin, it was over slaves. So, to those of you who are familiar with the Treaty of Amity, may also know it as the Jay Treaty. So those were two very important documents in the history of America, because it was the first treaty that ensured the right to travel between Canada, Britain, and any other outside areas, because they needed to have that type of treaty. You can't just wander into one land without having a treaty to back that up with the other. So some of you may not be able to read this, but if you could scroll in somehow, it'll say the Treaty of Amity Settlement and limits between the legislative... Actually, wait a minute here. Concluded between proclamation, ordinance for preservation and health, act of Congress establishing the territorial government, declaration of independence, Spanish regulation for the allotment of lands, to regulate the counties and establish inferior courts, regulating descents, authorizing the assignment of bonds and notes, regulating damages of bills of exchange, providing for an election of delegate to Congress, for the admission of attorneys at law. For all of this stuff in here, road from Pensacola to Cahaba, and to incorporate the city of Pensacola. So again, they have to incorporate it. This is just a fact of life. Regulating civil proceedings concerning usury and regulation of rates of interest. This was back when the states controlled the banks and before the federal government took over that.
That'd be nice.
And I personally think we should go back to this.
That would be nice.
Well, again, the Federal Reserve is an administrative agency. So concerning where...
Well, kind of.
Discussion for another podcast.
Agreed.
Concerning the guardians of wards and masters of pretenses concerning wills, adopting common law and certain statutes of Great Britain, and repealing laws and ordinances now in force. So again, that's all just sort of very important stuff that everybody really needs to look at. Now, the Jay Treaty says Florida Indians gotta go. And this is where you have the Trail of Tears. Now, I could have my history a little off, but there was a huge revolt right around that time that you can research into that I don't remember the history of. Ooh, you go, Gary. So let's go back to statehood, 1845.
The pitfalls of outdoor.
Federal control is lessened as the people direct their own government by representation. Statehood is intended to be a secondary line of defense for inalienable rights. Technically described, each state is its own country within a primary governmental framework. And Florida was created within the Founding Fathers' generations, reflecting the values of that era. So that's important to remember when we talk about the new stuff about what was in the Second Amendment and the cases in Bruin. We look at what the Founding Fathers intended when they created these amendments. So we, the people of Florida, having and claiming the right of admission into the Union as one of the United States of America, consistent with the principles of the federal Constitution and by virtue of the Treaty of Amity Settlement and Limits. Again, we didn't have land patents to start. Those came after all this.
So unfortunately for everyone, you have to find out what really happened. You have to do this. You have to go look and see what the legislature did and acted. And then, you're going to have to combine it with what Congress did. That's why we need specialty people, because it takes so much time and effort to dig to the real root cause of any of these things that, it takes a village, folks. It takes a village.
Exactly. And these same things that I'm looking through these acts of legislature are all these things. Now, let's go through some of these back then. Come back one more. An act to provide for the election of tax collectors. An act to amend the law approved March 15th to incorporate the inhabitants of different townships. An act providing the change of venue in criminal cases. An act to exempt homesteads from execution, attachment, and distress. Now, this is one of the two confusing things about homestead exemptions today. An act to secure rights to women. An act of replevelin. I can't even remember what that is.
That's the if you want to take possession of property, you can do a writ of replevin, which is what they did on to Zach for the Porsche, and that's how they got a judgment to get it, but they haven't gotten it.
The new name, filed off the serial number, and changed it.
Right.
Okay.
Yeah, and you have to provide proof of ownership, like a manufacturer's certificate or registration certificate of something of that nature, which did not happen in that last case, which is why it shouldn't be a valid thing. But these are very, very important acts that are going on all the time, and we don't see that anymore today because all these issues have been settled. But this is where you find the root cause. They're not just a bunch of idiots on the hill, or at least they weren't. They are now, but
I think
they do
without
nonsense.
a good, I believe we should have classes both in school and at the legislative level that are sort of like CEUs. Are you taking these constitutional studies? Are you seeing where these acts came from? All of this should be a matter of law.
Well, yes, and Rockefeller is another one. That is the guy
Well, that's up to us to write a bill for the legislature to put in.
Correct.
So, an act to repeal the charter of the Bank of Florida. So again, that was something states regulated it. An act declaring Hillsborough River a navigable stream. Now it's a highway. So because they have control over it, they can make you get a license. So that's where these control acts and whatnot came from. Now this was the first article, Section 1 of the Declaration of the State Rights. So now, defendant possessing property, protecting property, reputation, pursuing their own happiness. You see that in Mungler versus Kansas. All political power is inherent in the people. Okay, it's not the government. All men have a natural and inalienable right. See, these are words we've taken out of everything we have today. That the people have a right in a peaceable manner to the right to assemble and consult for the common good. That petition for redress, that means going to the courts too, people. That free white men of the state shall have a right to bear and keep arms. Now again, this was back before the Civil War. No soldier shall be quartered. No standing army should be kept up without the consent of the legislature. We're allowed to have militias, but not a standing army. We're not using our militias anymore. At least maybe we are, but I don't know what they're officially construed as.
Wouldn't that be private citizens in a militia?
Well, a militia is composed of the private citizens who volunteer for the duty.
Okay, but it's not organized by the state.
Well, it would have to be. Somebody has to take control, and so that might be the Home Guard. Or so that's something for somebody if they want to who's a military expert.
A topic for another time.
Yeah, that's another podcast. There's the military expert who wants to reach out to Gary after watching this. So there's all sorts of just to guard against the transgression of the rights of the people, we declare that everything in this article is accepted out of the general powers of government and shall forever remain inviolate, and all laws contrary thereto or the following provisions shall be void. That's the Ninth Amendment in a sense.
An action you're bringing, right?
So let's talk about creatures of the state. Back then, the act of legislature was what incorporated them. So an act to prescribing the method by which labor unions or labor bodies may be incorporated or allowed to do business. Which creates the in rem jurisdiction of ownership as a thing, including its real estate. And bestowing upon the corporate jurisdiction. Again, we didn't have the Secretary of State's Department of Corporate Business. That's an administrative feature that came later in the 1920s, 30s, or 40s. And this is our favorite quote by Alphonse. And for this exact reason why, it would be strange indeed if the legislature can't do it, then how does a body politic do it? Not a possibility of law.
Exactly. So these creatures of state are things that are created under the direction or authority of the state. So that's why these limited liability corporations were allowed to us to access them. So we can be part of the state and be protected under some of the laws, these tort laws, not to be sued under. So the advantage of doing that is people can't come take your home when you're incorporated under LLC. So that's what the state offers as protection. It's not dissimilar from how the mafia protects the business in New York.
Well, I'm going to flip that back on you because I just talked about the homestead exemption that protects us from creditors.
Yes.
So we have the constitutional right to protect ourselves from creditors that may be not being used correctly. People have to go look into their state legislature about this. Because the homestead exemption is the tax discount is not the same as the constitutional protection that protects you from creditors. What are you throwing confetti at me for?
I'm not trying to.
So I want to really define taxpayer here. An act to continue the rights and privileges and powers and franchises and grants of the Florida, Midland, and Georgia Railroad Company and extend the time of completion to the same. An act to amend Section 6 of an act entitled to grant certain lands to the Silver Springs, Ocala, and Gulf Railroad Company. So when you read these are the taxpayers that have prescribed rights in Florida's Constitution in Article 1, Section 25. Nobody's arguing it that way, and that is where I'm trying to lead the charge for everybody in Florida. Got to start invoking these rights in our state courts instead of allowing them to presume us to be taxpayers.
Yeah, and so the right to access the courts are protected in your state constitutions. And so when we're pleading the U.S. Marshal's case, access to courts, we had to link back to the Louisiana Constitution because there's a general one in the federal, but it's more specific in your state, and that's where we had to go find that right to access the courts.
Yes. So 1870 to 1911, transfer of control of corporations shifted from the state level to federal. Because it was the Ohio U.S. Standard Company, excuse me, that ushered in this administrative mess because each one of them was looking for a tax discount, and the Fed said, let's tax your income.
Be careful what you ask for.
Yes. So again, that is where we began the significant changes in control from state to federal level of the artificial entity regulation as well as the administrative state. Because the federal is a mimic of the state when we're basically being triple taxed in a lot of different ways because of these acts of legislature that we don't historically read about. So in Florida, chapters, these are each one of those textbooks that I was reading. Extra sessions, you get to 1927, Volume 1, Volume 2, Volume 3. There's all sorts of changes in here. Each one of these is 1,000 pages long easily in some cases. And this is why laws evolve. One large water pipe for tobacco use, please. But now here we are in 2024, just saying, let's get a bong to go get our medical marijuana with. Things change. Things change a lot.
Yep.
Florida's 6th Constitution. I personally believe we have the strongest state constitution in America right now. That's just me. Everybody can disagree and just whatnot with it. But we're the only state that defines us as natural persons. And that's a big key component to protecting natural rights over taxpayer rights. A lot of this is based off the canons of construction. So you guys have got to go get your free copy of Gallia and Garnier's Rule of Law.
Rule of Law.
And it's the standard for the legal argot we speak today. And argot is a specialized language. And in historical tradition, argot was the thieves' guild language. So ironically, that's what we're dealing with today, tax collections by a authorized thieves' guild, if you want to call it that. So,
and for those that don't know, the canons of statutory construction are how you can It's how you interpret a statute. And so there's 89 of them or so, something like that. And so there's only there's a few useful ones that are really used for deception, and the rest are just pretty much common sense, but things you have to go look at and be aware of when you're reading the statute, because things don't always mean what you think they mean, for not only in regular English grammar, but also in common day, and then also in the facts of the time period, and if there's a definition in the statute.
Well, yeah, I mean, it's just Gary was saying, these are here for you to follow. You can pause and go read them, come back to them. Now we're going to come to the right for subject is the right to possess property in all forms without direct taxation. It's a lost concept in America. We should know Article 1, Section 9, Clause 4, like we know the back of our teeth, and we've forgotten it. Property doesn't have rights. People have rights. And the right to enjoy property without unlawful deprivation, no less than the right to speak, is in truth a person's right, whether the property in question be a welfare check, a home, a savings account. A fundamental independence exists between the personal right to liberty and the personal property right. Neither can have meaning without each other. So this quote from Lynch versus Household Corp is probably the most valuable quote for anybody who's looking to fight the Tax Injunction Act. If you are not citing it at the state level, if you are not citing it at the federal level, you're screwing the pooch here. You've got to go read this case. My other favorite case here is Van Horn's Lessee versus Dorrance. I'm going to scroll up just a little bit here so people can read the bottom of that. But the Constitution expressly declares the right of acquiring, possessing, and protecting property is natural, inherent, and unalienable. Again, natural. It's not ex gratia from the legislature, but ex debito from the Constitution. It's sacred, for it is further declared that the legislature shall have no power to add to, alter, abolish, or infringe any part of the Constitution. Go read it. Lovely, lovely. It's I think it's at least 30-something pages, and it's a specific case out of Pennsylvania, which is at the time where our founding fathers were headquartered, I believe, right?
Philadelphia.
Yes. So Pennsylvania was very, very closely tied with what the intent of the Constitution was back then. So, no direct taxes. The 16th Amendment didn't change a thing for us. Of course, the U.S. Constitution still prohibits a direct tax on the people. The 16th Amendment only applies to the artificial entity's income. Now, you're going to want to go read Taft's letter, Congressional Record 1909, page 3344 to 3345. He is literally stating it only applies to artificial entities and their income. It's an excise tax on the privilege and not a direct tax on property. The 16th was meant to tax the profit of the rich who own the shares, robber barons. Your wages are your property. So let's dig into this a little bit. This is what Taft said. I therefore recommend an amendment to the tariff bill imposing all corporations, joint stock companies for profit except national banks, building and loan associations, those are people who build the homes, an excise tax measured by 2% upon the net income of such corporations. So everything is in here. The decision of the Supreme Court in the case of Spreckle Sugar Refining Company against McCain seems clearly to establish the principle that such a tax on this is an excise tax upon the privilege and not a direct tax on property, and is within the federal power to, without apportionment according to the population. The tax on net income is preferable to one proportionate to a percentage of the gross receipts, because it is a tax upon the success and not the failure. So everybody who's up in arms about this new unrealized gains tax, go straight to this letter. They will negate it in the bud automatically. It imposes a burden at the source of the income at a time when the corporation is well and able to pay and when collection is easy. Now collection's too easy.
Voluntary.
Lastly, that should read 39. Whoopsie, my bad. That's a Scrivener's error, as we like to call it. This is where the term individual was stripped from individual firm and used to denote an officer or an employee of a public officer. So this came about right before World War II. So that's when this whole hot mess came about. And because everybody was working for the government in some form during World War II, you were in essence a government employee. You were either overseas, you were helping in the war effort, you were running all of this, so you were somehow subject to this Public Salary Tax Act. But for those who were not, nothing was taxed.
So they used war once again to trick us into all becoming taxpayers.
Well, there is also potentially
And
the
the love of
Social
country.
Security Act.
And the love of country to do it.
Yes, and the love of country. I'm supposed to do this, not I have to do this. So again, there it is. You notice like the back of your teeth. And we're going to go over these definitions for the purpose of property taxes, and then we're going to do another break. Definitions. Income tax is not a tax on property within the constitutional provisions requiring uniform tax on property. Property within a constitutional provision requiring ad valorem tax is distinguished from income and means corpus of estate or investment from which income flows. Income tax held not in violation of constitutional provisions requiring uniformity is allowed to because these taxes were reasonable and not arbitrary. Ad valorem, this Latin term is used in commerce in reference to certain duties called ad valorem duties, which are levied on commodities at certain rates per centum on their value. We know that is millage, just a new name today.
All right, programming note, we've had a bunch of technical difficulties. I finally got my camera right. It looks good. So anyway, we're back with Benny and we're going into property taxes, right? The history, kind of. Florida history.
Well, we just went through the history of how you should be looking at the legislative acts of property taxation, how just to study what did your society do before it became what it is today. And without that reference, today doesn't make sense. The silent epidemic that affects every citizen when they buy a home. You get property taxes after you buy your home. Why? What's going on here? And just like Beetlejuice, you just about can't get rid of the damn thing.
If only you could just say his name 3 times.
That would invoke him, not get rid of him.
It does both, right? It invokes him and then it gets rid of him. That's why he silences people.
I think so. Yes. So how did we get here? Like we were discussing earlier, people were patriotic. We continue to volunteer to pay taxes as individuals. Wickard versus Philibert created a misconstrual of level over private property, which was a wheat growing case saying that a farmer who is a taxpayer cannot grow wheat in his own property, especially if he's getting a loan from the Department of Agriculture. Then Caroline Products, U.S. versus Caroline Products, inflated the whole issue even more. We were reconditioned in schools to speak and not speak legal argot anymore. That was the importance of homeschooling. Our children knew what we're supposed to be studying, so children I teach, this is all stuff I teach them if they have an interest in it. But again, this should be taught in the schools. This should be taught to the legislature. This should be taught to everybody. This should be like, well known.
And it was before 1913 or so when Rockefeller took it out of the schools. So
well, pre-Great Depression. But even then, we'd had 2 minor banking crises. Prior to that, they had the first Great Depression, and they had the second Great Depression, and then you finally had the Great Depression, which was in FDR changed everything to administrative. So that's again, things changed, and everybody went, okay, that's what we're supposed to do, because they didn't realize what the history was.
And no one wants to talk about the Roaring '20s when Calvin Coolidge cut spending and taxes, and it created a huge boom, which was followed by the Great Depression because of what the banks and the elites did. But anyway,
So it is a very, very interesting time, because right in the middle of all of that mess was the passing of the 16th Amendment. Then you had all of Justice Taft, Supreme Justice Taft's rulings. After he stopped being president, he became the Supreme Justice. He understood clearly what was going on here, and then it got muddied after he left. So, an interesting note, side note, going back to that Public Salary Tax Act, there was a huge row over the justices about whether or not they were supposed to pay that tax. So you can look into a lot of that stuff there. We start with inalienable rights, and that's protected by the federal Constitution, further protected by the state constitution. Both of them use statute. Both of them use code, but the local county and administration of affairs are ordinances. But that is also governed by code. So no matter what, you start with your constitution, then you go to the statutes telling you how to govern it, or the ordinance telling you how to govern it, and the code controls that. And I believe if the code is empty, it's an administrative interpretation, and it's now not valid under the downfall of the Chevron defense. So all of those of you who are complaining about what can I do, there's plenty of opportunities for you here to say, we can't do a construal of an administrative agency anymore. Because if they can't do it with the SEC, how can they do it with your little rinky-dinky county?
right.
So, preamble to Florida, we the people, being grateful to Almighty God for our constitutional liberty. Right there, it's saying we have constitutional liberty that comes from God, nowhere else. Declares the inalienable rights. Recall Lynch versus Household Court. Article 1 in Florida is for the people. The remaining affairs define offices, crimes, privileges, trafficking, public health, and other regulated issues. They are all after Section 1. That's why I say Florida is one of the best constitutions. It is clear, concise. It is the statutes that are misconstrued
And misapplied.
So here in Florida, we've enshrined the 9th Amendment in Section 1, Article 1, Section 1 of our Constitution. The enunciation of certain rights shall not be construed to deny or impair others maintained by the people. When two rights occur in one person, it is the same as if they were two separate persons. So we have inalienable rights and prescribed rights. Mungler versus Kansas, my absolute favorite case. If we are writing the assumption that the citizen stands before the law in a dual character, both as an individual and a member of society, that in the former status he has certain natural rights not surrendered to society, but reserved to himself and necessary to his pursuit of happiness, and which the law cannot take away. This was right after the enactment of the 14th Amendment. So this was an important case that described how the states could regulate beer making. And a guy named Mugler had just built an entire brewery. Nope, no more brewing beer for you. Not even for medicinal purposes. I thought, well, maybe it was. That was the simple exception. But from there, this case, Mugler versus Kansas, is cited often, long, loud, and hard. And even this year in the D.C. courts in 2024, they've cited it. So if they've cited this, you can use this as a legitimate part. We just have to call our natural rights out. Section 2 of the Florida Constitution. All natural persons. You won't find this anywhere in any other constitution in the United States as far as I'm concerned, so don't go crazy looking for it. You have to look for verbiage that follows. Are equal before the law and have inalienable rights, amongst which are the right to enjoy, defend life and liberty, to pursue happiness, to be rewarded for industry. That's saying no direct taxes. To acquire, possess, and protect property. Now, when we did this constitutional amendment back in 1998, citing from the gentleman who helped create the 1968 Constitution, The term natural was interposed to clarify that this provision does not apply to corporations, but only private persons. So, for those of you who are looking to induce your legislatures to rewrite a constitution, Florida's got a great model for you. Artificial entities do not have gender, further isolating who has what kind of rights and is subjected to the artificial canon. Taxpayer's Bill of Rights. Why are we granted rights? Prescribe and adopt a Taxpayer's Bill of Rights that sets forth taxpayers' rights and responsibilities and the covenant responsibilities to deal fairly. Now, if we go all the way back up to where I showed you that one passage, an act to continue the rights, the privileges, the land grants, and everything, that is the taxpayer. And these are the prescribed rights set forth by the legislature. So this was introduced, I believe, in 1980. It excludes natural persons who receive due process. But you have a due process within the tax remedy, so there's double verbiage here. Taxing means a privilege is in play. That's it. Otherwise, you have the liberty to use everything.
No
Privilege include license for driving as the business of transporting persons or property for hire on the highway. See the Motor Vehicle Act of 1938 in Florida. That one actually talks about the regulation of guns. So that's when you begin to see there's a license for carrying a gun while you have a license for doing a privilege.
Yeah, so no state can take a right, turn into a privilege, and tax it. So that's why it's telling you right now, if you're paying taxes, it's dealing with a privilege. And so while they could have probably made this whole act about a sentence or two, because of the confusing language, we have to make it long and lengthy. You know, the lies always has a lot more words to it than the truth.
Yeah, so once you begin to read and you naturally speak the argot and translate the language, it's going to be a whole lot easier for you. Now, Article 1, Section 9, Clause 4 is right here in Article 7, Section 1A of the Florida Constitution. No tax shall be levied in pursuance of law. No state ad valorem taxes shall be levied upon real estate or tangible personal property. That's saying no direct taxes. All other forms of taxation shall be preempted to the state, except as provided by general law. Section 1B. Motor vehicles, boats, airplanes, trailers, trailer coaches, and mobile homes as defined by law shall be subject to a license tax for their operation in the amounts and for the purposes prescribed by law, but shall not be subject to ad valorem taxes. So after I'm done with this property tax, I have another property tax. Because why is my RV? It's being used as a recreational vehicle, not a piece of real estate to generate income. Does not need to have a license plate on it, nor do I need it to go from point A to point B in the state.
Very valid point.
Oh, that escalated quickly, wouldn't you say, Gary?
Yeah, indeed. Indeed it did.
So it is according to Florida Statute 220, it is the legislative intent of the legislature. It's the intent of the legislature in enacting this code to impose a tax upon all corporations, organizations, associations, and other artificial entities which derive from this state or from any jurisdiction permanent and inherent attributes not inherent in or available to natural persons. This is tricky language.
Indeed. Yes, it is.
So to me, this is saying you have to be incorporated by an act of legislature or submission into the department in order to get prescribed rights that are not inherent in or available to natural persons.
Which goes back to your creature of the state, what you had a slide on earlier. Creatures of the state. So if a municipality has to have a grant from the legislature to have a charter to act as does an LLC or a corporation or anything of that type, would definitely have to.
Yep, an act to continue the rights, the privileges, powers, and franchises, and land grants.
Exactly. So creatures of the state are things created under the authority given to the state. So LLCs, corporations, municipalities.
Definitions. So this is important for you guys because everybody's hunting where to find the definition of an ad valorem tax. I suggest you go look at the income definitions for a taxpayer because they're going to use tricky verbiage elsewhere. And in this case, in conjunction with taxing by millage, ad valorem taxes paid means 96% of property taxes levied for operating purposes, income and expenses. So it does not so all of this is business. Everything after it is business operation. So if that's ad valorem taxes paid on business operation, why are we paying it? Well, let's go back to something here for a second. Levied. Levied means to actually place the tax on you. Assess. That's what we haven't seen yet. And then you have collection.
We've seen collection.
Oh, yes, years and years of collection. Now, going back to this, continuing the same code, taxpayer means any corporation subject to the tax imposed by the code and includes all corporations for which a consolidated return is filed. So if they have no consolidated return, how do they know you have income and expenses in order to classify the use of the property? So continuing the entire tax statutes, which is Title 14 in Florida, a taxpayer means the person or other legal entity. Taxpayer, consolidated return, administrative code, person, including any company, unless specified. The word company may be used interchangeably with the word person. Clever legal language again.
Yes.
Taxpayers are granted specific rights. Why do I need administrative code to grant me rights? So again, follow it through. Utilize reducing generis, no juris socius, artificial person can, and all of that. It is the intent that the tax is measured by net income, thereby imposed on every taxpayer earning or receiving income in this state, or being a resident or citizen of this state. It shall be in addition to all any occupation, excise, privilege, and property taxes, and the jurisdiction or authority of the state. The state doesn't have natural inherent jurisdiction over us. So you guys have to remember all of that. And we go back to Taft's letter. It is the privileges and excise tax measured by the net income for the privilege of conducting corporate business. So everything is in parallel here. Returns and records to determine whether taxpayers are liable for the tax under this code. Again, this is why I named the Department of Revenue. Shall prescribe reasonable rules and regulations for the assessing and collection of taxes, and such rules and regulations shall be followed by these people: property appraisers, tax collector, clerk of court, and value adjustment boards. So that's what you guys can research. You tie it all in. Some of you might have a board of assessors. Are those the guys who create the policy for these people? You just have a different title. But who creates the rules for the board of assessors? The Department of Revenue. So you just sort of have to follow the shit that rolls downhill. Statutes reflecting income and records. Did I put that up here? No, that's a different one. Shall be able to obtain access to, where necessary, financial records relating to non-homestead property. Shall be provided in those instances in which it is determined that such records are necessary to determine either the classification or the value. Value, important word. Classification, all inquired items by law to be on the assessment rolls must receive a classification based on the use of the property. And then finally, this is the big kicker for me. Now coming back to it, no remedy within the VAB. This is the big key for some of you to go and find. And what is ending up happening in Florida, you are required to submit a return to the assessor before you have access to the value adjustment board, which immediately knocks out 90% of us. I have no administrative remedy. Hearing procedures and an assessment may not be contested unless a return was required by 193.052 was timely filed. And there's the case law supporting this. Holding the taxpayer may not withhold requested income information from an appraiser and then subsequently challenge the appraiser's assessment. I'm in a reverse situation. I have no income and I shouldn't even be challenging this. Now let's go to that statute 193.052. This is where they scream in court. No return shall be required for real property ownership. We don't have to have a return. Sorry, I have no remedy without it.
And what's required? A return.
A consolidated return?
Right.
So that's why we went through the statutes in this order. All returns, all forms used for returns shall be prescribed by the department and delivered to the property appraisers for distribution to the taxpayer. What form? I got no form. So now we have circular logic. Buffalo chicken look like this or this. Or what if a giraffe was a centaur? That circular logic, we're never going to know the answer if we don't focus on the issue here. Personally, this one looks tasty.
Anything's possible.
So, tax collector duties. We're going to go down to the bottom here. Erroneous, incorrect, inconsistent with the law or the facts. If a tax collector has reason to believe that a taxpayer has filed an erroneous or incomplete statement, must notify the property appraiser of the erroneous or incomplete statement. Correction of erroneous assessments. Any collector who discovers an erroneous assessment shall notify the property appraiser. There's an assessment that's not supposed to be in here because until he creates an assessment, it can't go on the tax rolls. The tax collector shall notify the property appraiser the account is invalid and the assessment may not be certified for a future tax roll.
And can't seems to be a fungible word for them. Not absolute.
They're tougher than me when they read. Now, Florida, since 2009, I believe there was a very important Georgia tax case in the 11th Circuit around 2008, or another Supreme Court ruling. And suddenly I've noticed a lot of the states have shifted the burden of the proof to the assessor as of 2009. So for those of you who are looking for clues, go look at 2008, 2009, 2010 and see if anything changed around them. So it is the express intent of the legislature that a taxpayer shall never have the burden of proving the property appraiser's assessment is not supported by any reasonable hypothesis. In other words, I think it's right. And that's what's happening.
Seems good.
This section is intended to clarify existing law and apply retroactively. Now, this is the second chapter of 194.3. This is the only two statutes in it. In any administrative or judicial action in which a taxpayer challenges an ad valorem tax assessment of value, the property appraiser's assessment is presumed correct if the appraiser proceeds by the preponderance of evidence that the assessment was arrived at by complying with this statute and professionally accepted appraisal practices. Again, repeats it. The value of the property must be determined by an appraisal methodology. So twice in this statute, you've got to have it. This is what Alphonse has been screaming. Where's the USPAP? So when you asked for a signed assessment, it is those accepted professional appraisal practices that they're supposed to be following. These are the statutes. Factors to consider in deriving just valuation. Shall take into the consideration the following factors. Now, there's confusing verbiage again. The value of, the just value, the market value, that they are confusing you intentionally. This is the one they can't prove, and it's the most valuable one for us. Because they must consider all 8 or their assessment is set aside. There's 3 approaches to valuation: the cost less depreciation approach, the sales comparison approach, and the income capitalization approach. The value of, there we go, so this is the case I was referencing to, 2007, when they started changing things. The value of property must be determined by an appraisal methodology that met the criteria section in professional appraisal practices. Garden Restaurants Incorporated. See also CSX Transportation versus Georgia Board of Equalization. So this is when it all changed for us, everybody. Unlike any changes, it takes 10 to 20 years to shake out a little bit of issues. So we have the Uniform Standards of Professional Appraisal Practice. Just value means the appraisal, but does not mean 193.017 as an appraisal value. That's what I'm missing in there. All Floridas must follow USPAP and provide a signed appraisal. They just claim they don't have to. An appraiser's valuation must be based on careful scrutiny of all the data available. Under the Uniform Standard appraisers must identify the characteristics of property that are relevant to the intended use of the appraisal. This just came out this year in October. F&L Fiduciary Services, LLC versus Solomon. Solomon is the property, Aisha Solomon, property tax collector of Alachua County property. Other states often have USPAP as their licensing requirements. Now, it's important to note here.
And USPAP,
Florida statute.
USPAP is
Uniform Standards of Professional Appraisal Practice for property appraisers, but it's also used uniformly across other professions. A real estate agent uses it. A property appraiser in general uses it. A lawyer uses it. We all have to be able to understand the same subject, which is why it is the professional standards.
And using the same metrics. You have to use the same metrics.
So that's why you look into your statutes. This is why I went to it. Florida Administrative Code 12D 9.018 regulates who can come before the Value Adjustment Board. An employee of the taxpayer, that's not me, or an affiliated entity may represent the taxpayer. One of the following professionals may represent the taxpayer: an attorney, a real estate appraiser licensed or certified under 475, a real estate broker licensed under Chapter 475, a certified public accountant licensed under 473, but they should still be able to understand these references. And this is where we are today. I'm trying to figure out how to make this apply to them. Court cases. These I found in the Value Adjustment Board's training manual promulgated in 2023 by the Department of Revenue. So go to the department's promulgation. What are they supposed to do in an administrative remedy? What are they supposed to do in judicial remedy? All of these things are required by them to follow and give you clues as to where to look. That's how I found out that I have no remedy within the Value Adjustment Board. The whole Parch canon. I found somebody showed me that my current Attorney General has cited this. So you can use this against them. All parts of statutes must be read together in order to achieve a consistent whole. Where to start your search? Read the state constitution and find your inalienable rights. It's Article 1 for me. Then you have your taxpayer rights. And for most of you will be in on Article 7, which is taxation, defined as a whole. I'm lucky that the state of Florida defines it in Section 25 of Article 1. Locate your state statutes, taxation and finance. Read everything. Just save a copy. Put it in a pile on the toilet and read it while you're in the bathroom. Okay, this shit sucks. I'm just going to keep reading. Do what you have to do. Research the codes of statutes. In Florida, it's FAC 12D. Find your tax manual. Read the current USPAP, and you can find it by Google. Other projects, how to get your feet wet. Declaratory statements rulemaking for MMJ and hemp. I did that for the Administrative Procedures Act. That's how I learned how to use that concept. I learned how to do a petition for a writ of habeas corpus for cut. That taught me how to do all petitions in general. I just have to find the right statutes, jurisdiction, and stuff that governs it. You know, in this case, the Constitution only requires minors' parents to sign a form, but the statute states the form is voluntary, but I still have to sign it, and the code describes the form as mandatory for our patients. So I did a petition for rulemaking to get property removed from the assessment roll. That was with the DOR. Drafted a petition. I cited these statutes, but all of these, they were denied. But what matters is you're trying to do something, and if you want to learn how to draft a pleading, if you want to learn how to do discovery in a way that affects your state in a positive fashion, you can do it this way. It's just up to you to learn that new concept. The end is here.
Fried chicken.
So I just want to thank everybody for sitting through this. This is a very long session, but you guys, everybody needs a starting point to do this, and I'm hoping that this will give you that.
And thank you for bearing with all our technical difficulties. The lights were being blown down, and but I think our microphones are much better. So y'all let me know on that if that sounds better. And I think the camera got better. Mine was bad, but Benny's was good from the get-go. He's got an Apple. He's got an IMAX. That tends to work. But Benny, thank you for being here.
It's been a pleasure. It's been a pleasure, and I look forward to coming back on for some other subjects.
Absolutely.
And good news.
And good news for sure. Yeah, he served their his lawsuit to him the week before Christmas. So they either have to work on it during Christmas, or, you know, of course they could call and relent, I suppose. Anyway,
so,
yeah. So I'll give you the last word.
Yeah, but I mean, even then, that's playing the game. I didn't have to do that, but they've been not so nice to me in court, so I served everybody right now. We will have good news for those of you who want to follow this along. If you go to the Alphonse channel, I'll keep everybody up to date as to what's going on in the groups, and Gary will share over to the Big Sib group. I am hoping eventually that a lot of people will want to join the hearing as interested parties, because we have problems with this property taxation, and we're also citizens with questions about this direct tax. Just remember, your state says no direct tax shall be levied somewhere, and that's up to you to go find it.
All right, kids, get to work, get to reading. We'll see you soon.